So very good evening all the participants to this new batch of limited insolvency examination. Let me share my screen with you. So I hope my screen is visible. Is it visible now?
Yes, it's
Yes.
coming.
Okay.
Yeah, come.
Okay. So first things first. So as we all know, there are two ways of reading a particular thing. Like there are two ways of eating your meal. You can eat chapatis first, dal later, then sabji and raita. So you will not relish the meal. Similar way, our code has been made in such a way that various things are there and there is no interlinking. Interlinking has not been provided by IBBI or even by books. In books also, you will find everything. You will find code, you will find regulations, you will find rules, but there is no linking. So what we have done is we have interlinked them. In the section itself, you will find a reference to a particular rule or regulation. So you can just click on that and you can directly go to that rule or regulation. So today it's going to be very basic. So basically, the target is to have a balanced perfect score to qualify the examination. Like there are basically two challenges which the students face. Sometimes what happens is that people are good in IBC, people are good in code, but they are not good in this allied laws. So that is also a big challenge. So this allied laws is also a big challenge. Just a minute. So I hope you have already gone through the syllabus. And in the syllabus, almost 80% of the questions they will be from the insolvency and bankruptcy code, and 20% will be from the allied laws. So allied laws, they cover 19 marks. So 19 marks out of 100, you cannot ignore them. So it's equally important to have a deep understanding of the allied laws. So what we will be doing is we will be sharing with you our already recorded video lectures on various allied laws in which all the allied laws have been discussed at length, right? There are 72 case laws also. And regarding those case laws also, so we have prepared a material because case laws they cover only 5 marks. So I think by going through our material, you will be able to comfortably answer those questions. So this is the syllabus. I hope my syllabus is visible. So here in this, what you will find is that code and regulations. So code and regulations are of 10 marks. So basically, 1 mark questions, 10 questions from the code. Then business laws and allied laws. Just a minute. So business laws, which include Companies Act is not entirely covered. There are various chapters which are covered, but we have to go through these chapters. And for each and every chapter, we have developed our material. Recorded lectures are already there, which you can go through at length. And we'll be also discussing some of the important provisions of the Companies Act. Then Partnership Act, LLP Act, Contract Act, Sale of Goods Act. Then the general laws. General laws cover 7 marks, and there are, I think, more than 10 allied laws. So basically, 13 allied laws are there, various acts are there, including SEBI regulations. Then finance and accounts and general awareness of 2 marks each. And then case laws, 5 marks, 72 case laws are there. But the most important part is the case studies. Now regarding case studies, as you all know, this IBC and on IBC alone, 62 marks are given for case studies. This IBC, as you all know, is a procedural law. So basically, what it does, it describes the various processes. Like CIRP is one of the process, liquidation, voluntary liquidation, pre-pack, fast track, fresh start, individual insolvency, bankruptcy. So these are the various processes. And on either of these processes, they may frame a case study. So this case study is very important, which basically they will give you a particular situation and they what they want to test basically. ये ना प्लीज आप अपने को म्यूट कर लीजिए ऑडियो सेटिंग्स because otherwise there will be echo. So the case studies, they are based on various processes in which they want to analyze a particular situation and they want to see, they want to test how you will react to a particular situation which you will be facing as an insolvency professional. So this is the coverage of the examination. Examination, you all know, is being held on daily basis. So every time you have to pay a fees of 5,900 rupees. Duration is 2 hours and wrong answer, there is negative marking also. And you have to secure at least 60%, right? And if you are not able to pass the exam, then with a gap of 21 days, you can again appear in the examination. This is the list of case laws which we'll be going through. This is the model test paper which is given on IBBI website also. Just
वो आज जिसने कर ली वो पास है कर लेंगे उन्हें तो भाई बात करनी पड़ेगी और चीज़ों में भी एक्सपर्ट हो जाओगे फिर तुम इसी में जितने इसमें होंगे सारे वही होंगे
right. So
कितनी देर का है ये लेक्चर
So now this is the basic framework of IBC. But let us basically understand what is the logic behind introduction of this IBC code and why it is called a code, not a act. It is defined as a code because it is all encompassing. Section, rules, regulations, all combined together, they are called as insolvency and bankruptcy code. It deals with insolvency and bankruptcy of not only individuals but of corporates also. So everybody is intended to be covered here. Although notification has been made only for corporates as of now and individuals and partnership firms or non-corporate entities, unless they have stood as guarantor to a corporate person, are not yet covered under IBC. So DRT or normal civil code route is available for them. The idea behind introduction of IBC was to have a comprehensive law which deals with various types of entities, and it is basically a welfare legislation. The idea is to help the companies. the idea is not recovery. Basic idea behind this IBC is the to help the companies recover from the insolvency situation which they are facing. Let us read the preamble to the code. So what it says the objective of the IBC. I hope my screen is visible. Is this visible? I hope.
Yes, visible. Yes.
Oh, okay. So the objective is to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner. Because earlier also, prior to because this IBC came in 2016 only, so there were laws earlier also prior to this, like winding up of companies was being handled by high courts. Similarly, SICA was there, then SURFACE, RDB Act was there. So various laws were there which were dealing with insolvency and this bankruptcy situation of corporate and non-corporate entities. But now the intention is to bring all such things at one place and to deal it in a time-bound manner. Time-bound manner is important because delay leads to value destruction. Suppose there is an insolvent company and you are not able to decide the fate of that company for 10 years. So in the meantime, the plant will get rusted. So there will be value destruction. So they say, whatever you want to decide, you want to run the company, you decide in a particular time frame. You want to wind it up, do it in a time bound frame. So time bound manner. And time bound manner that will lead to maximization of value of assets of such persons. It will promote entrepreneurship. How it will promote entrepreneurship? Because new entrepreneurs will come. The existing entrepreneur is not able to handle the crisis which the company is facing. So a new entrepreneur will enter who will take over the company. There will be availability of credit. How the credit will be available? Because the credit which was stuck in that particular company, the new entrepreneur which is coming, he will infuse funds into the company and balancing the interest of all the stakeholders. So balancing the interest of all the stakeholders is also an important aspect because various stakeholders in the company could be the persons who have given loan to the company, persons who have supplied goods and services,
लाइव
employees, government departments, and so on and
कुछ
so forth.
खाने को दे दो
So all
कुछ भी
these,
दे दो
so they will balance the interest of all the stakeholders, including alteration in the priority of payment of government dues. So this is also very important aspect because in earlier laws like income tax, sales tax, GST, etc., what is the aim? The aim is let the government dues be recovered first. Like in income tax, we will find what it says. It will say that the income tax dues can be recovered as areas of land revenue. But here they are putting it themselves at a lower pedestal. There is an alteration in the priority of payment of government dues. And you will be surprised to find that in IBC, even government dues may not be recovered fully. So there may be a haircut which may be proposed to the government dues also, which was unheard of in earlier situations. And to establish an insolvency and bankruptcy board, because this insolvency and bankruptcy board is the regulator. So this is the regulator which is regulating the various persons, various stakeholders. They are regulating the insolvency professionals, they are regulating the insolvency professional agencies, insolvency professional entities, information and utilities, etc. etc. An effective legal framework for timely resolution of insolvency and bankruptcy would support development of credit markets and encourage entrepreneurship. It would also improve ease of doing business and facilitate more investments leading to higher economic growth and development. So this was the preamble to the code and they say because whenever they introduce any act or code, so they will say why it is being introduced. So they said this is the objective. So objectives are time bound resolution, maximization of the interest of all stakeholders, availability of credit, balancing the interest of all stakeholders, alteration in the priority of payment, etc. etc. And so all these things we have to keep at the back of our mind while taking any decision. So because everything, whatever is written in the act or code, that is governed by the objective which is
नमक
behind
पाए
that act.
तो मैं बोलना चाहिए था ना फिर ज्वाइन करेगा
ये भी रख दो।
इसी में डाल लूंगी ना वो कितने करते हैं
So in the budget speech in 2014-15, Arun Jaitley, the then finance minister, had stated that entrepreneur-friendly legal bankruptcy framework will be created for small and medium enterprises to enable them to exit business easily. Because in earlier regime, exit was not easily available. So they said, if a person is not able to run the business successfully, let him take exit. Because he said that entrepreneurs were stuck with the business organizations year after the business failed, making them face the ire of labor unions and government authorities. Starting the business is easy, but exiting it wasn't really a choice for them. The process of exit was too complex. Suppose if you want to wind up a company, so it's quite complex. To bring back the confidence of the entrepreneur, it was essential that the bankruptcy framework be reviewed and reformed. So this is said in the budget speech in 2014 and 15. So then bankruptcy law reforms committee was formed under the chairmanship of T.K. Vishwanathan, which gave its report in two volumes. So there are two volumes. Volume 1 is text of findings and recommendations, and volume 2 is the draft insolvency and bankruptcy code. And most of the recommendations of the Vishwanathan committee were implemented.
Sorry for interruption. Are you
Yes, yes.
showing any screen here, or because we are seeing only the folder names?
Oh, okay. Let me again share it. Just a minute. I hope now it is visible. Is it visible?
Just a minute. Yeah, now it is.
Okay. So, setting up of this Vishwanathan committee, this Vishwanathan committee said that the failure of some business, if you start a business, it might succeed, it might fail. So, failure of some business is integral to the process of the market economy. But when a business fails, so what is best? Best is either to you renegotiate it, right, between the financiers to finance the going concern using a new arrangement of liabilities and with a new management team. So if this cannot be done, then you go for rapid liquidation. So they said whatever you want to decide it quickly. So when such arrangements can be put into place, the market process of creative destruction will work smoothly with greater competitive vigor and greater competition. And they say it is a two-step process. You don't directly jump to liquidation. You first try to resolve the issue. Resolving the issue could be by bringing some new management, and if that is not possible, then go for liquidation. So, noticing that the existing process of rescuing the companies is susceptible to manipulation as it allows the debtor promoter to seek endless extension. Because in case of winding up, what we experience that winding up cases were going on in courts for say 10 years, 20 years. So committee sought to restrict the resolution period to 180 days with a maximum of 90 days extension. So they said seriousness will come into decision making if the time is shortened. So at the first instance, insolvency resolution process will be underway in all cases, but if it remains unsuccessful, then liquidation is triggered. So this two-step process of resolution and liquidation was suggested by the committee in each and every case of insolvency and bankruptcy if the debtor commits a default or unable to pay its debts to the creditors. So they said you try it in every case. So committee strictly avoided bringing in arms of the government. So they said basically you keep those arms of the government at a bay, legislature, executive or judiciary. So they say let the creditors take over. So notable aspect of the committee report was the recommendation of appointment of regulated private insolvency professionals. So they said you develop a team of insolvency professionals which will oversee this entire process to handle the insolvency resolution process and then liquidation. So there was deliberate attempt to keep away the official liquidation from the insolvency process. Distribution waterfall. So there is an altered distribution waterfall here. So the distribution waterfall, it kept the government dues at a priority below the unsecured financial creditors. So they said, let the government wait. There is no hurry for the government to recover the taxes, what is due. So they said, if the economy grows, if the business comes back, so then the government will also get its share. So they say everybody will be benefited. The committee also observed that the government also will be the beneficiary of this process as economic growth will increase revenues. It also felt that efficiency enhancement and consequent greater value capture through the proposed insolvency regime will bring in additional gains to both the economy and the exchequer. There is a concept here of simplified fresh start process also, because some people might be stuck in this process who may not be able to pay anything because of limited scope. Like as of now also, we experience various facilities, say for farmers, like the waiver of loans is there. So this is something similar. So people with very limited means are allowed a fresh start process whereby they are not required to pay anything. Speed is the essence. So speed is of essence for the working of the bankruptcy code. So they said it will ensure quicker decision making. Setting up of a regulator. So this committee suggested that you establish a regulator, you establish an Insolvency and Bankruptcy Board of India, which will oversee the functioning of insolvency professionals and information utilities. This is the list of earlier committees. But what is the basic difference between the earlier committees and this new committee? This new committee had the mandate of a comprehensive reform. So they said you rewrite the whole law. Earlier committees, they were tinkering with the existing laws only. But this here, they looked at debt recovery laws in a holistic manner, leading to deeper redesign of the entire resolution process rather than working on strengthening any single piece of it. So let us now understand what is this IBC and what is the basic framework in which we are working. So central government, as you know, is at the top, and the central government, by way of a notification, they made IBBI, that means Insolvency and Bankruptcy Board of India, as the regulator, which will oversee this entire process. So IBBI is the regulator, and this is the website of ibbi.gov.in is the website of this IBBI. And whom they are regulating? IBBI is regulating insolvency professionals, which may be individuals or which may be entities. So it is regulating both insolvency professionals as individuals and insolvency professional entities. They are regulating the insolvency professional agencies as well. And as of now, there are 3 insolvency professional agencies: IIPICI.in, IPAICMAI.in, and ICSIIP.com. So these are the 3 insolvency agencies, which are basically promulgated by the 3 institutes: CA Institute, CS Institute, and CMA Institute. So anybody, any insolvency professional can be a member of either of these 3 agencies. So this is something similar to a college. Like if you are doing any course, so what you will do? You will take admission in a college. You will enroll yourself with a college. So similarly here, as insolvency professional, you are required to enroll yourself with an insolvency professional agency. And you have to register yourself with IBBA. Similarly, like a student will get admission in a college and he will be regulated by the university also. So similarly here, and university will be regulating not only the student but the college as well. So similarly here, IBBI is regulating not only insolvency professionals but insolvency professional agencies. So, but insolvency professionals, they are regulated by both, by the agencies as well as the IBBI. Similarly, information utilities are there, basically which are a repository of the financial information like debt taken, debt discharge, charge created, charge satisfied, etc., etc. So NESL is the only government utility which is basically a repository of financial information, something similar to MCA or CERSAI. So this is one side of the table. On the other side is the process whereby a person who has given a loan, he is normally referred to as financial creditor in IBC. So he can make an application for starting this process. Similarly, an operational creditor who might be a supplier of goods or services, he might be an employee, he might be a government department like customs, income tax, excise, etc. So financial creditors, operational creditors, and the corporate debtor itself. So they can make an application. So what is the trigger point? Trigger point is the default. So if there is a default of 1 crore rupees or more, so either the financial creditor or operational creditor or corporate debtor can move an application to NCLT, which is the adjudicating authority. And for individuals and partnership firms, the adjudicating authority is DRT. For orders of NCLT and DRT, if you want to appeal against their orders, so you can go to NCLT and DRT, and ultimately the appeal lies to Supreme Court. So this is the basic framework. Just a minute. Now let me share with you the bare code. So I hope my screen is visible. Is it visible? No. Right. So I hope now it is visible.
Yes, it is
Good.
visible.
So what we have done is I've already shared this PPT, which contains not only the code but the rules and regulations also. So we have given an index at the beginning, and whatever process, as I already told you, there are various processes in this IBC. One is the corporate insolvency resolution process, whereby the corporates are targeted for resolution of their insolvency. So that is why it's called corporate insolvency resolution process. So you have to read not only the sections but the rules and regulations also. Rules basically they outline the various forms, and regulations they describe the process in detail, right? So sometimes there are rules and regulations, and sometimes there are only regulations and no rules. So accordingly, for each process, you will find a set of 3 or 2. Just right. So what it says, this is an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons. I hope my screen is visible. And where from I am reading. Partnership firms and individuals in a time-bound manner for maximization of value of assets of such persons, to promote entrepreneurship, availability of
Actually,
credit,
screen
and
is not
balance
visible to us. It's
the
just
interest
off
of
screen.
all the stakeholders, including alteration in the order of priority of payment of government dues, and to establish an insolvency and bankruptcy board of India, and for matters connected therewith or incidental thereto. So this is the preamble,
गुप्ता जी
right?
स्क्रीन विजिबल नहीं हो रहा है एक्चुअली.
मेरा
आप
स्क्रीन विजिबल नहीं है?
आप स्क्रीन आ रहा है सिर्फ.
विजिबल है सर.
नहीं, it is visible. It is visible. Yes.
सागर जी आप कहाँ से देख रहे हैं, मोबाइल से या उससे?
बाय लैपटॉप.
अच्छा. एक बार ऑफ करके दोबारा करिए, होना चाहिए. ऑफ करके मतलब
मैं छोड़ के मीटिंग छोड़ के दोबारा आता हूँ.
हाँ.
विजिबल है. मतलब द सेकंड सेक्शन एप्लीकेशन द प्रोविजंस ऑफ दिस कोड शैल अप्लाई टू, वहां से क्लास सी तक आप विजिबल है.
हाँ इतना ही
शायद
है.
बाकी सब देख
इतना ही है.
हाँ.
हाँ
ओके डन.
इतना ही है. ओके. So,
It's okay now.
okay, thank you. So, section 1. Section 1 says that this code may be called the Insolvency and Bankruptcy Code 2016 and it extends to the whole of India. Then you will find the star marks here. Why star marks? Because earlier part 3 was not applicable to J&K, but after this reorganization act, whereby this J&K was also inducted into India and all the rules and regulations, so no separate rules and regulations as of now are there for J&K, which was a privileged state earlier prior to this abrogation of Article 370. So now all the provisions of IBC are equally applicable to J&K also. And the beauty of this is that it says that it shall come into force on such dates as the central government may by notification in the official gazette provided that different dates may be appointed for different provisions of this code, right? So it was introduced in phases. So there were various notifications whereby, and even as of now, the provisions relating to individuals and partnership firms have not yet been notified, right? Now, section 2, it says to whom this act applies. So this act applies to any company incorporated under the Companies Act, or any under any previous company law, any other company governed by any special act, because there may be some companies which are not governed by Companies Act, but there is a separate act for them, like Food Corporation of India, LIC. There are so many companies for which separate acts are there. So for those companies will also, to those companies also this IBC will apply. But except insofar as the said provisions are inconsistent with the provisions of such special act. Because like if in LIC Act also, so there is a provision regarding winding up. Suppose some situation arises whereby this LIC is required to be wound up. So if those provisions are there and IBC also contains some provisions, so provisions which are contained in that special act will prevail. This is the meaning. Any LLP incorporated under the Limited Liability Partnership Act, such other body incorporated under any law for the time being in force, and the central government may by notification specify in this behalf. So for this, you have to notify. It says such other body incorporated under any law in force. So please note that it is not only restricting it to bodies incorporated in India. It could be any body corporate, right? Under any law for the time being in force. But the central government will have to issue a notification for that, right? Then personal guarantors to corporate debtors. Why personal guarantors to corporate debtors have been identified separately? Because, as I told you, provisions regarding individuals and partnership firms have not yet been notified. But because individuals had given guarantees to corporate persons and provisions regarding corporate persons have been notified, so it was necessary to carve out a special class of these personal guarantors to corporate debtors. Like take the case of Mr. Ramlal. There could be two scenarios. Number one, Ramlal has taken loan in his individual capacity and is not able to pay. So whether he can be brought under IBC? The answer is no as of now, because rules and regulations are not there notified. But now take the second situation. XYZ had taken a loan. Ramlal is a director in that company and Ramlal has given a guarantee. So in that situation, action can be taken under IBC against Ramlal because he is a personal guarantor, right? So personal guarantors to corporate debtors, partnership firms and proprietorship firms and individuals other than persons referred to in clause E. So it says it will apply. So section 2 says that the provisions of this code shall apply. So why they are saying shall apply? Because whenever they are notified. In section 1, what we have read? In section 1, we have read that different dates may be appointed for different provisions. So it's not necessary that when this act is enacted, everything is notified in the first instance itself. So it says it will be introduced in phases. It will be notified in phases. And that is why section 2 says it shall apply, right? In relation to insolvency, liquidation, voluntary liquidation, or bankruptcy, as the case may be. So it says it applies to everyone: corporates, companies governed by special acts, any other body corporate, right? LLP, personal guarantors, partnership firms, proprietorship firms, individuals. Now, section 3. Section 3 contains definitions. Section 3 is there in part 1, but there are definitions in some other parts also. So the definitions which are given in other parts, they apply to that particular part, but the definitions which are given in section 3, they apply to the entire code. So what is that is why they say in this code. If we read section 5 also contains some definitions, but it will say in this part. So let me show you section 5 also side by side. So this is section 5. In section 5 they say in this part, right? But in section 3 what they are saying? In this code. So definitions which are given in section 3, they apply to the whole of the code, where definitions which are given in section 5 or section 79 or various other sections, they apply to that particular part only. So these are very basic definitions. Board means the IBBI. Bench means a bench of the adjudicating authority. Then there is a concept of bylaws. As I told you, one of the organs of this insolvency process is the insolvency professional agencies. So how many insolvency professional agencies are there as of now? Three, right? So what they make, these insolvency professional agencies, they make bylaws. And what IBBI makes? IBBI makes regulations. And who makes the rules? Rules are made by the central government. So these basic things we have to remember: rules by central government, bylaws by agencies, and regulations by the regulator. Naturally, regulator is IBBI, right? So charge. Charge means an interest or lien created on the property or assets of any person or any of its undertakings, or both, as the case may be, as security and includes a mortgage. So why it is important to understand the definition of charge? Because normally the loan may not be granted without any charge. So normally charge will be created. So that is why it's very important to understand the definition of charge. So charge means an interest or lien created on the property or assets of any person or any of its undertakings. Person here means not an individual, but it will include companies, etc., etc. We will read the definition of person or any of its undertakings, or both, as the case may be, and as security includes a mortgage. Can anybody tell me the meaning of undertaking? Any of its undertakings?
Sir, in total.
Undertaking here means, like suppose a company has got 5 lines of business. It is into real estate also. It is into hotel business also. It is into say some other venture also. So it includes a part of the business. Like suppose they want to create a charge on the hotel property only and not on the hospital. So that is why this concept of undertaking is there, right? So chairperson means the chairperson of the board, and board, wherever we are mentioning here, board here means IBBI. Like in income tax, if we are referring to the board, so board means Central Board of Directors is there. So here board means the Insolvency and Bankruptcy Board of India, and chairperson means the chairperson of the board. Another important definition is of claim. Now, what is this claim? So claim means a right to payment. Whether or not such right is reduced to judgment, that means a judgment might not have come against that claim, but you have got a right. How you can get a right? Suppose you are a worker. So how you will get a right to payment? Suppose you are a worker, you are working in a company. So how you will get right to payment? When you have worked for that company, when you have rendered your services. Suppose if you are a supplier, how you will get right to payment? When you have supplied the goods, right? Similarly, suppose you are a financial creditor, you have given loan. So when you will get the right to payment? When you have paid the money. So right to payment. Now this right to payment may or may not be reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. So long as there is a right to payment, so you are entitled to claim. But there is a difference here. There is a difference between a person who can claim a money and who can file a petition for initiating in this insolvency process. Every claimant may not be having a right to initiate this insolvency process. Like we read in a chart that financial creditors or operational creditors or corporate debtor can initiate this process by making an application to the adjudicating authority, which is NCLT, in case of corporate persons. But the question is whether any supplier, whether any worker can start this process. The answer is no. There is a minimum amount, there is a stipulation, there are conditions which, if fulfilled, only then you can initiate this process. But once this process is initiated, whether you have got a right to claim, the answer is yes. Because once a company comes into insolvency and there is a public announcement, everybody who is having a right to payment, he can claim the money from the company, right? So this is the difference. So claim means right to payment. Second is right to remedy for breach of contract. What is this right to remedy for breach of contract? It must be different from the right to payment. Because if you have entered into a contract and you have breached that contract, there is a breach of contract. So naturally, if there is a breach, then the other party has a right to remedy, right? But what sort of right? If such breach gives rise to right to payment, right? So any breach which gives rise to right to payment, that is also covered under claim. Let us understand by way of an example. You are executing a civil contract. There are terms and conditions which have been settled into with your client. The client says, okay, I will give you free supply of steel and cement, and you are required to mobilize your machinery and you are required to mobilize your resources. Now, if the client does not provide you free steel or supply or cement and you are not able to perform your part of the promise, so naturally there is a breach. Now the point is, if such breach, if there is a condition that okay, if any of the parties does not fulfill its part, then there is a right to claim liquidated damages. So that right to claim liquidated damages, that will come here at right to remedy for breach of contract. This is the meaning, right?
Sir, I have a question, sir.
Yes, yes, please.
Sir, this says disputed or undisputed.
Right.
Now, if there is a real dispute between a payment and any debtor, can that also be taken to this initiated insolvency proceedings?
No, actually, in case of now they say as we read in the preamble itself, they say it's not a recovery mechanism. So if there is a dispute, then you cannot initiate this insolvency process. In case of operational creditor, so an operational creditor who is having a dispute, suppose there is a worker, right? And there is a dispute between the management and the worker, right? So and that worker is entitled for say an amount of 2 crore rupees. So he will not be able to initiate this process of insolvency against that company. Why? Because the amount is disputed. But in case of financial creditor, this condition does not apply. In case of financial creditor, they say even if dispute exists, you can file a petition. So there are different conditions for financial creditors and operational creditors. But here we are talking of claim. Once a company comes into insolvency, if the dispute is yet to be settled, so then also he has got a right to claim. How much claim will be admitted? Only the undisputed amount will be admitted. And why he has got a right to claim? Because here this claim, now we are settling the accounts of that company. We are trying to find a new buyer for this company. So the new buyer must be knowing what could be the liabilities. Let me explain to you the logic behind this claim. What is the logic? The logic is the company is into insolvency. That means the existing management is not able to run the show. So they are looking for a new buyer. Now, as a new buyer, what you would be interested in? You would be interested in that as to what are the maximum liabilities against the company, right? Those liabilities may be disputed or undisputed. So to disputed liabilities also, you will assign a particular thing that okay, how this could be the amount of liability that could come. So that is why they allow to be filed a claim against the disputed liabilities also. This is the meaning. I hope now you get it. Salesh.
I have a question.
Yes,
Sir,
please.
no,
See,
sir, what I feel is that this disputed and undisputed, it can be misused either from the company or from the financial data.
No, no, no. Actually, it is a factual situation. If there is a dispute, so naturally it is a factual situation. Dispute means what? Dispute also has been defined here in IBC. They have given a definition of dispute.
Hmm. Okay. Okay, sir. Thank you.
Yes, please. MBS Suresh Kumarji, you were saying
yeah,
something?
yeah. My question is, this claim means this contingent claim also will come into picture, or only certainty of the claims only will be considered?
No, no, it says no. It says legal, equitable, secured or unsecured. So everything will come here. Now regarding contingent, so it's what they say. It says basically, if there is a contingency, then for contingency they are making a provision basically. So about that we will read in detail that regarding basically the intention why it is important to understand the definition of claim. The definition of the understanding of this definition is important from the standpoint of view of the new buyer which is coming. So he would like to know what are the liabilities which he might be required to pay because the existing person is not paying. Now he's taking over that company. So naturally he will have to settle all these things. And he will be settled with disputes also because to the new buyer also these disputes will travel.
Okay.
Corporate person. Corporate person means a company as defined in this Companies Act, LLP, or any other person incorporated with limited liability under any law for the time being in force, but it shall not include any financial service provider. So there is a definition of corporate person here. There is a definition of corporate debtor also. And they say corporate person shall not include a financial service provider. Why? Because for financial service provider, now who are financial service providers?
Bank.
Yeah, basically banks, NBFCs, where people are interacting because people are interacting with these financial service providers. So there is a lot of public confidence involved. So they have carved out a special procedure for them. For such financial service providers, they have carved out a special procedure which is given in section 227, which we'll read. Because suppose you have the banker has given you a loan, you are a company, banker has given you a loan, so the banker can initiate proceedings against you. But suppose you have supplied goods to or services to the bank and the bank is not paying. So whether you will be able to initiate proceedings against the bank, the answer is no. Not in normal parlance. There is a separate procedure for that. So like this Diwan Housing Finance was not paying. Many NBFCs are not paying. So there is a separate procedure because there is a separate regulator for them. RBI is regulating those financial service providers. So they will take the permission. They will take that regulator also into confidence. But for normal companies, there is no such regulator. Now you may say that, okay, for listed companies, SEBI is the regulator. So wherever SEBI is the regulator, SEBI is also issued notice that, okay, this company is into insolvency. Now corporate debtor. So there is a difference between corporate person and corporate debtor. So corporate debtor means a corporate person who owes a debt to any person. And corporate person need not be owing a debt. So why this distinction? Why this distinction they have made between corporate person and corporate debtor? Because here we might be dealing with voluntary liquidation cases also where there is no debt due. So voluntary liquidation cases will be covered under that corporate person. But where there is any debt due, then they will be covered under corporate debtor. That is why we will notice that when we will be reading the provisions related to voluntary liquidation, so they are using the concept of corporate person. But for others, where debts are due, they are using the word corporate debtor. So core services means services rendered by an information utility. So as we have already seen, NESL is the only information utility and they are rendering some services. So this definition they have given, about which we will read in detail when we go to the information utility provisions. Right? Creditor. What is the meaning of creditor? Creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, secured creditor, unsecured creditor, and a decree holder. So all these are included under the definition of creditor, right? So even a decree holder is considered as a creditor. Debt. Definition of claim we have already seen. Right to payment and right to remedy for breach of contract, which gives right to payment. Now debt. Debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. So debt, they say, it is a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. So even if a person has given a debt, whether he will be able to initiate the process, the answer is no. There has to be a default also, right? And default means non-payment of debt. When whole or any part or installment of the amount of debt has become due and payable and is not paid. So if something is due and it is not paid, then alone it is considered to be a default, right? Then financial information, financial institution. These are the various definitions: financial product, financial service provider, financial sector regulator. Financial sector regulator, this means an authority or body constituted under any law for the time being in force to regulate services or transactions of financial sector and includes RBI, SEBI, IRDA, Pension Fund Regulatory Authority, and such other regulatory authorities as may be notified. So financial sector regulator is also there. Why this definition of financial sector regulator is important? Because they say financial service providers are kept outside the definition of corporate person. So there is a separate procedure for initiating insolvency process against financial service providers. And financial service provider means what? Financial service provider means a person engaged in the business of providing financial services, which are outlined above, right? These are the financial services. In terms of an authorization issued or registration granted by a financial sector regulator. Suppose there is a private money lender. So whether that private money lender will come under financial service provider, the answer is no. Because he is not being regulated by a financial sector regulator. Right? Insolvency professional means a person enrolled under section 206. Like we take roll number in college. So similarly, here you get yourself enrolled with an insolvency professional agency as its member and then registered with the board. So both these things are important. Enrollment with IPA and registration with board. Insolvency professional agency means any person registered with the board under section 201 as an insolvency professional agency. 3 agencies as of now. Information utility, only one. means a person who is registered with the board as an information utility. So these are the definitions. About all these we'll read in detail later. Notification means a notification published in the official gazette, and the terms notified and notified shall be construed accordingly. Person, this definition is very important because person includes an individual, HUF, company, trust, partnership, LLP, any other entity established under statute, and includes a person resident outside India, right? And person resident in India, this definition you will find in clause 5 of section 2 of FEMA. Person resident outside India means a person other than a person resident in India. Prescribed means prescribed by rules. These two words you will find quite often. Prescribed, as may be prescribed. So prescribed means prescribed by rules, and rules are made by the central government. Similarly, you will find the word specified. So specified means specified by regulations made by the board. Now property, this definition is also very important because property includes money, goods, actionable claims, land, and every description of property situated in India or outside India, and every description of interest, including present or future or vested or contingent interest arising out of or incidental to property. Regulations means regulations made by the board. Schedules means the schedule annexed to this code. Secured creditor means a creditor in favor of whom a security interest is created. And security interest means right, title, or interest or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation, and includes mortgage, charge, hypothecation, assignment, and encumbrance, or any other agreement or arrangement securing payment or performance of any obligation of any person. So this is the definition of security interest, to which we will again come back, provided that security interest shall not include a performance guarantee. Specified means specified by the regulations made by the board. Transaction includes an agreement or arrangement in writing for the transfer of assets or funds, goods or services from or to the corporate debtor. Now it says transaction includes an agreement or arrangement in writing. So normally, why it is important? It says transaction includes. So whether oral agreements cannot be enforced? The answer is no. Even there could be oral transactions also. That is why they are saying includes. It doesn't, because in interpretation of statutes, there are two terms. One is means, the other is includes. So means wherever used, it normally says that it is an exhaustive definition. And wherever the word includes is used, it means something more could be there than what is written. So transaction includes an agreement or arrangement in writing. That means transaction could also include an agreement or arrangement orally made, right? In writing for the transfer of funds or assets or goods or services from or to the corporate debtor. Transfer includes sale, purchase, exchange, mortgage, pledge, gift, loan, or any other form of transfer of title, right, possession, or lien. Workman shall have the same meaning as assigned to in clause S of section 2 of Industrial Disputes Act. Basically, workman here excludes the employees of prison, military, Air Force, and Navy, right? And words and expressions. So there are some definitions which are not given in IBC. Then they say you take those definitions from Contract Act, Partnership Act, SCRA, Securities Exchange Board of India, RDB, LLP, Companies Act, etc. etc. So you take respective definitions from there. So these are the basic definitions which are given in section 3. Now let us see section 4. What it says, this is covered in part 2. And they say application of this part. So this part shall apply to matters related to insolvency and liquidation of corporate debtors where the minimum amount of default is 1 lakh rupees, right? Provided that the central government may by notification specify the minimum amount of default of higher value which shall not be more than 1 crore rupees, right? So in the act itself, they have enacted a enabling provision that okay, central government will simply issue a notification and they will increase the amount to 1 crore rupees. Now the question is, if they want to increase it beyond 1 crore, so then there has to be an amendment to the act, right? But up to 1 crore, if they want to increase, they will issue a simple notification and the amount will be increased. Provided further that the central government may by notification specify such minimum amount of default of higher value, right? The value is here is 1 lakh rupees. With the central government can increase up to 1 crore rupees. But in case of pre-pack, it says minimum may be higher value, right? Which shall not be more than 1 crore rupees for matters relating to pre-packaged insolvency resolution process of corporate debtors. And along with this, we have to read the regulation number 1 and 2 also. So if we see what is regulation 1 and 2, this is regulation number 1 and 2. So amount of default, minimum is 1 lakh, which the central government could increase to 1 crore rupees, and they have already issued a notification for this purpose. So as of now, the minimum amount of default for initiating process is 1 crore rupees. In case of pre-pack, it is 10 lakh rupees minimum. We have already read some definitions in part 1, which apply to the whole of the code. Now we will read some definitions which are applying to this particular part, because now we are in part 2. So it says, section 5 says, in this part, unless the context otherwise requires, adjudicating authority for the purpose of this part means the NCLT. So adjudicating authority is NCLT here, which is constituted under section 408 of the Companies Act. Auditor means a chartered accountant. Base resolution plan. So there is a concept of base resolution plan also, which is there in case of pre-pack, about which we will read in detail. Some of the definitions may not be understandable at this stage, but when we'll read the provisions in detail, then we'll again come back to these definitions. Chapter means a chapter under this part. Constitutional document in relation to a corporate person includes articles of association, memorandum of association of a company, and incorporation document of a LLP. Corporate applicant. So why this definition of corporate applicant is important? Because in case of corporate debtor, the application can be made by corporate applicant also. So corporate applicant means the corporate debtor. Corporate debtor means a person who owes a debt to any person, right? So there is a difference between corporate person and corporate debtor. Corporate person कौन है? जरूरी नहीं उसने debt लिया है, but corporate debtor कौन है? Who has taken a debt. So corporate applicant means a corporate debtor or member or partner of the CD who is authorized to make an application. Individual who is in charge of managing, like say CEO, CFO, etc. A person who has control and supervision over the financial affairs, say a CFO. Then corporate guarantor. Corporate guarantor means a corporate person who is the surety in a contract of guarantee to a corporate debtor. The corporate debtor has taken a loan and another company has stood as guarantor. So that is corporate guarantor. Guarantee may be given either by an individual or by a company. If the company has given the guarantee for a loan taken by another company, then the company is the guarantor, that will be referred to as corporate guarantor. If an individual has given a guarantee, he will be referred to as personal guarantor, right? Dispute. So we were discussing the definition of dispute. So dispute, here it says dispute includes a suit or arbitration proceeding. Includes means there could be a case where no suit or arbitration proceeding has been filed or it's going on. Still there could be a dispute, right? So it's an inclusive definition. When this bankruptcy law reforms committee report came, so there they used the word means. So they said dispute means, but when this IBC law came, so they changed the word to includes. So it says it will include more things also. So it is an inclusive definition instead of an exhaustive definition. So dispute includes a suit or arbitration proceedings relating to the existence of the amount of debt, the quality of goods or services, or the breach of a representation or warranty. So normally, because one person may say that, okay, I have given the loan, second person may dispute it. So naturally dispute exists. So it could be regarding the existence of the amount of debt. So when, suppose a financial creditor files a petition before NCLT, which is the adjudicating authority. Now what the other party will say? The other party will say that there is no debt which is subsisting. It is in the form of equity only. So for equity, whether you can initiate proceedings under IBC, the answer is no, right? Second could be regarding the quality of goods or services. Because in case of debt, there cannot be quality. In debt, there could be question of existence, whether the debt exists or not. Debt may not exist when it is not a debt at all. It's an equity. But regarding goods or services, there could be a deficiency in quality. So, if there is a suit or arbitration proceeding relating to the quality of goods or services, right? Suppose you are a supplier and you have supplied goods worth 5 crore rupees to a company, right? So here, suppose the company is saying that the goods which you supplied are not of good quality, not as per the specification. So whether you will be able to file a petition, the answer is no, because a dispute is there regarding the quality of goods or services. And it is not a recovery mechanism. This IBC is for the benefit of the companies which are into financial trouble, not for the benefit of people who have given loan or given goods or services, or the breach of a representation or warranty. Financial creditor. Financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. So there is a concept of assignment of debt also. Suppose there is a debt. So what they do? They normally, what they will do? They will assign it to some other person. Like the asset reconstruction companies are there. So they will assign their debt to that particular company. So the original financial creditor will move out of that scene and that asset reconstruction company will come into position. So that asset reconstruction company will also be deemed as financial creditor. So it says financial creditor means any person to whom a debt is owed and includes a person to whom such debt has been legally assigned or transferred. So if there is a legal assignment of debt, then also it is considered as financial creditor. Financial debt means a debt along with the interest, if any. So why they are using the word if any? If any means there could be a case where there could be a interest-free debt, right? Suppose a holding company is giving loan to its subsidiary company. So they could be giving interest-free loan also, right? So financial debt means a debt along with interest, if any. So you cannot say that if no interest is payable, then it's not a debt at all. So there could be a case where no interest is being charged by the other party, but still it is a financial debt. So financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money. Because debt is normally given for a period of time, because it is intended to be used in business, right? If you give money today and you want it back tomorrow, so then there could be trouble. So it says it should be against the consideration for the time value of money and includes money borrowed against the payment of interest, right? Any amount, the amount raised by acceptance under an acceptance credit facility or dematerialized document. So there could be various types of debt, right? Straight debt may be given by one person to another. There could be CC facility. There could be note purchase facility. Suppose you are going to an outside market, you are going to a foreign market. So then there could be there are certain people, there are certain underwriters which say that okay, in case your bonds are not subscribed, then we will purchase them. So that is the concept of note purchase facility. So basically, if any person undertakes to pay your undertakes to subscribe, so that also, and if you are raising any amount pursuant to any note purchase facility, so that is also covered under financial debt. Received, sold or discounted other than any receivables sold on non-recourse basis. What is the meaning? There are some receivables, you are entitled to receive some money, but you get it discounted, right? Or you sell it. Now there could be two means of selling or this discounting. One way of discounting could be that okay, you are assigning your debt itself, right? Then it is on non-recourse basis. But if you are getting it discounted with a condition that okay, if ultimately the person doesn't pay, then I am responsible and you are not responsible. So that is the concept of sold on non-recourse basis. So if any receivables are sold or discounted other than any receivables sold on non-recourse basis. So this is something similar to concept of factoring or bill discounting. Any amount raised under any other transaction, including any forward sale or purchase, having the commercial effect of a borrowing. So here, home buyers are also included into the concept of financial debt. Derivative transaction, counter indemnity obligation, amount of any liability in respect of any guarantee or indemnity. So all these are various types of financial debt. But debt, as we understand, is different from equity. So financial debt only is covered and equity is not covered. Financial position in relation to any person means the financial information of a person as on a certain date. Just a minute. Information memorandum means a memorandum prepared by a resolution professional. Initiation date. So there are two dates. One is the date of filing. Suppose you are filing a petition before NCLT. So one shall be the date of filing. So that date is known as initiation date. So initiation date means the date on which a financial creditor, corporate applicant or operational creditor, as the case may be, makes an application, right? But what is the insolvency commencement date? That insolvency commencement date is the date when the application is admitted, right? So there could be a gap between this initiation date and insolvency commencement date. Why it is important? Because it is specified in the act itself as to where we have to see the initiation date and where we have to see the insolvency commencement date. Then insolvency resolution process cost. Why this definition is important? Because it is to be paid first of all. Even before we pay any financial debts or operational debts, this insolvency resolution process cost is to be paid first of all. So insolvency resolution process cost means the amount of any interim finance and the cost incurred in raising such interim finance. Now, what is the definition of interim finance? Interim finance means any financial debt raised by the RP during the insolvency resolution process period or by the corporate debtor during prepack and such other debt as may be notified. So, if you are facing insolvency, if you are facing financial crunch, so you will get some money from outside. So that is the amount which is raised by the RP during this insolvency resolution process period, right? Why this interim finance is important? Because you want to run the company. You don't want to close the company. First of all, you want to try whether it is possible to run the company, right? So interim finance, And whosoever is giving this interim finance at this stage, when the company is into doldrums, so naturally he also deserves some priority. So this insolvency resolution process cost, it includes the cost of interim finance and the cost incurred in raising such finance. So this amount of interim finance will be paid first, right? Then the fees payable to any person acting as RP, resolution personnel, any cost incurred by the RP in running the business of the corporate debtor as a going concern. Because even after this insolvency petition has been admitted, you will try to run it as a going concern and there may be some costs involved. So those costs, they have to be paid in priority to the earlier dues. So there is a distinction between the dues up to the insolvency commencement date, which include the dues before the admission stage, and then the expenses or the costs which are incurred by the corporate debtor in order to run that business during insolvency period. So that is also given priority and it is included under insolvency resolution process cost, right? Any cost incurred at the expense of the government and any other costs. Insolvency resolution process period, because it is considered to be a time bound process. So this insolvency resolution process is the period of 180 days, right? And time runs on day-to-day basis. There are no holidays, etc. Right? So from 0 day to 180 days. It will end on the 180th day with no gap in between. Interim finance, we have already seen. Interim finance means any financial debt raised by the RP during this insolvency resolution process period. So what is important to be paid? Any interim finance raised, cost incurred in running it as a going concern, fees payable to the RP. All these are expenses or costs which are to be paid in priority. So that is why this definition is important. And this insolvency resolution process cost is to be paid in priority before any financial or operational debt is paid. Liquidation cost means any cost incurred by the liquidator during the period of liquidation, and liquidation commencement date means the date on which the proceedings for liquidation commence. And liquidator is also an insolvency personnel. So liquidator means an insolvency personnel appointed as a liquidator. Officer for this purpose, because there could be some penalties on the officers also. So officer also has to be defined. So office for the officer, definition officer, we will refer to the Companies Act or LLP Act. Then operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Operational debt means a claim in respect of provision of goods or services, including employment. So an operational creditor could be a supplier of goods or services. He could be an employee. He could be government department, central government or state government department or local authority, right? So all these are included in the operational debt. Personal guarantor. Personal guarantor means an individual who is the surety in a contract of guarantee to a corporate debtor. So there are two definitions. One is corporate guarantor, another is personal guarantor. Then there is a concept of preliminary information memorandum, which is used in case of pre-pack, about which that we will read in detail later. Pre-pack in insolvency commencement date means the date of admission of this pre-pack process. Pre-packaged insolvency resolution process, something similar to insolvency resolution process cost. Related party, very important definition of related party. But before we go to this definition, let us read the other definitions, and related party we'll cover at length in another lecture. Why this definition? But let us understand the basic behind this related party, why it is important. Because if you are entering into a transaction with a related party, the chances are that you might have given them some preference. So they are to be viewed more suspiciously. Their look back period will also be more. So we have to identify whether the transaction is done with a related party or with an unrelated party. In case the transaction is with an unrelated party, then the chances are less that there will be manipulation. But if you are doing a transaction with a related party, then you have to view it more suspiciously. That is why this concept is important. Then related party in relation to individual. So these are all given definitions. Resolution applicant. This definition is also very important. This resolution applicant means a person. We have already seen the definition of person, which could be an individual, partnership firm, HUF, trust, company, etc., etc. Right? So resolution applicant means a new buyer, a person who individually or jointly with another person submits a resolution plan. So he is somebody who is suggesting a resolution. He is submitting a plan to resolve that crisis which the company is facing to the RP pursuant to the invitation made. And resolution plan means a plan proposed by the resolution applicant. Okay. Then resolution professional. Resolution professional means an insolvency professional appointed to conduct the insolvency resolution process or the prepackaged insolvency resolution process. Voting share. This voting share concept is also important. Voting share means the share of the voting right of a single financial creditor in the committee of creditors, which is based on the proportion of the financial debt owed to such financial creditor in relation to the financial debt owed by the corporate debtor. So, as we find the claims, so whenever the claims are filed, our this IBC law is based on UK law, which says that let the creditors take over. Earlier regimes, before this IBC came, our laws were based on the US law, which says that the debtor shall continue to stay in control despite the fact that there is a default. Like in earlier cases, when IBC did not come, then what we used to see that the management continued to stay in control. Management was not divested of its powers. But in IBC, which is based on UK law, they say that if the existing management is not able to perform, then let the creditors take over. And creditors also, they give precedence to financial creditors. Why? Because they say the logic is that financial creditors are those persons who have provided finance to the company. So it is on their money that the company is running. So then let those people take the decision. So let them form a committee. Now what shall be the way and how they will vote? So they say that voting share means the share of the voting right of a single financial creditor, which is based on the proportion of the financial debt. Suppose total debt is 100 crore and a person is having a debt of 10 crores. So then how much vote share he will get? 10%. So this is the meaning and very logical also. So voting share is based on the proportion of the financial debt owed to such financial creditor. So we have covered up to part 2, chapter 1 only, and the definition of a related party and section 6 onwards will continue in the next class, which will be held on Tuesday. If you have any questions or if you want any clarification, you are welcome. This was the first class. So naturally, there may be many questions in your mind, for which you will be getting answers in the times to come. But if you still have any questions, you can ask. You can ask the questions in the group also. You can go through these sections. We have covered up to section 5, excluding the provisions relating to a related party, which we'll separately deal with in the next class. Right? So any questions up to section 5?
I have one question.
Yes, please.
Whatever we are talking, corporate or company, everything,
Right.
it's only company registered under the Companies Act. That means foreign companies are not included. Am I right?
Actually, let me explain it to you by way of an example. Suppose there is a foreign company and that foreign company has supplied goods to an Indian company. So whether that foreign company, because that foreign company is an operational creditor, right? So first question, whether an operational creditor can file a petition, the answer is yes. The minimum amount of default should be 1 crore rupees and there should not be any dispute. Details we'll read later. But let us discuss this basic question which you have raised. So the operational creditor, which is a foreign company, they can also initiate proceedings against the Indian company which has taken the goods but which is not paying the money. Right? So there is a debt due and there is a default. Now let us reverse the situation. Right? The reverse situation is that Indian supplier has supplied goods to the foreign company. Right? So now whether the foreign company can take an action, the answer is yes. But that is basically the question of jurisdiction. So only action can be taken against Indian companies. Action cannot be taken against foreign companies. Foreign companies can take action, but action cannot be taken against foreign companies. This is the meaning. Suppose a foreign company is not paying, then you will have to file a petition in that company because the jurisdiction will be of their country. That is the meaning. There
Okay,
is a
got it.
US company which is not paying. You are an Indian supplier, right? And you have supplied goods to a US company which is not paying. Whether you will be able to file a petition in India, the answer is no. But if there is a US company which has supplied goods to an Indian company, then petition can be filed against the Indian company. That is basically a question of jurisdiction. If you was that your question or you have some other question in mind?
Yeah, you're right. You're right. That's only my question. Yes,
Hmm.
understood.
Right. Hmm. So basically that is jurisdictional issues.
I have one more thing. You
Yes,
said one point you told that specific act versus the IBBI Act. Because LIC, suppose act, any clause, conflicting thing is there. Clause of the specific act will get override the IBBI clause. Am I right? Or the other way
No,
around?
no, you cannot say because here they say if something is not defined,
Hmm.
if so like you don't find the definition of turnover in IBC. So for the definition of turnover, you will go to the Companies Act. Similarly,
Mhm.
similarly, there could be various other terms which are used in the act, but because everything cannot be defined in one act, so they say you go to those acts. So if you find a definition under Contract Act or LLP or Companies Act, so you go to those acts and you find the definitions there. That is the meaning. The question of overriding effect is something different. That is governed by Section 238. Now regarding the overriding effect, if we read the rules of interpretation of law, so what is the rule regarding interpretation of statutes? They say there could be conflict amongst various laws. Like suppose IBC is one law, there is Limitation Act, there are various other acts. So if there is a conflict, then which one will prevail? So the rule of interpretation says that whichever is later legislation will prevail. This is the first logic, which is normally adduced. Second logic is if there is a central legislation and there is a state legislation, then central legislation will prevail. Right?
Correct. Got it.
Another rule is that the rule of harmonious construction. So they will try to harmonize the various laws because the intention of the government is to make them both, to make the laws work. So the law, whatever is made, it is intended to be made workable. So they will try to find a situation in which a harmonious construction could be adduced to that law. And but if one is to give way to the other, then the judiciary will decide which is to give way to the other. And the supremacy, so that is the rule of supremacy. So rule of supremacy is central state, central will be supreme, right? Later, earlier, later will be supreme. So these are the rules of interpretation basically. But there is a specific section here. It says, notwithstanding anything contained in any other law. So the rules of IBC will prevail. But there is this non-obstante clause you will find in all laws, not only in IBC, but in income tax also you will say, notwithstanding anything contained in any other law for the timing in force. So this
Yeah.
notwithstanding anything contained in any other law for the timing in force, you will find in all the legislations. But
There
what
the
will
question.
ultimately happen, that is subject to judicial interpretation.
Okay, got it. Thanks, got it.
Yes. Any other question? Okay. So what we will do is, I think you will be having questions after you read this part 2, CIRP part. So once CIRP part is complete, then we'll be giving you some tests also, online tests also we have developed. We have got developed some MCQs also. And we'll be side by side reading the case laws also. Right? So there are various case laws which are in our syllabus. So we'll be dealing with those case laws also side by side. Whenever we are reading a particular section, so whatever are the uh, case laws pertaining to that particular section, that will be also discussing side by side. So thank you so much.
Thank you. Bye.